Today we are going to talk about the subject of contract labor and what are the two key changes that the codes bring in terms of the restrictions around hiring contract workers in core activities and the very definition of contract labor itself. The Contract Labor Act in spirit expected that organizations do not engage contract workers in activities that are core to the organization, with the requirement for state governments to issue notifications to identify and notify activities in which hiring of contract labor is prohibited. The implementation has, however, been very different. In reality, the number of such notifications are very few and far in between, due to which it's pretty common to see that organizations do hire contract workers in even mainstream core activities. What the codes are now going to do is, by definition, prohibit the hiring of contract workers in any activity which is considered as core to an organization. There is not going to be any further state notification which would define what is core or prohibited. This would therefore require organizations to take a very close look at how their workforce is currently structured, where they're currently deploying contract workers, what type of activities they fall under, do they potentially fall into the definition of a core activity, and therefore how they will need to adapt their workforce to be able to continue to do operations in a manner that are legally compliant. As part of this assessment, what organizations will also need to do is take stock of what exceptions there are under the codes to the definition of core activity and whether they could benefit from one of those exceptions in the manner in which they do operations. Now, the issue of the definition of contract labor itself needs to be discussed. Before the codes, hiring of any worker through a third-party contractor in or in connection with the work of the principal establishment or the principal employer has always been defined as contract labor. Now, over the years, some high courts have interpreted this to mean that if somebody is a regular employee of the vendor or the contractor, meaning those individuals haven't been engaged specifically for the activities of a particular principal employer, then those individuals should not be treated as contract labor. What the courts are now doing is that they are formalizing this interpretation by redefining contract labor to exclude workers who are on the permanent payroll of the vendor, who are given contracts of employment, who are given hikes, social security benefits. What therefore this is going to do is it's going to impact how you choose your contractors and vendors and for what types of activities. And that's going to have a material bearing on, again, how you go about designing your org chart and workforce going forward, especially if you want to benefit from the updated definition of contract labor. Given the significant changes that these codes are about to bring, I think it's crucial for all organizations to take a very close look at how their workforce is currently structured. This assessment has to be done now to make sure that as an organization, you are staying on the right side of the law.